generally, which is also utilized in the instant complaint. Now that also Honorable Supreme Court finds fault. In fact, in SP money, Lordship must have noticed, it's a firm. So from a firm, the discussion goes to that of a company. The reason why such an elaborate discussion was required was, firm is described under Partnership Act, company, under an old 1956 and 2013, but the negotiable instrument statute, recognizes both as a single entity, which is highly erroneous according to certain corporate laws. The reason being, in a company there are certain liabilities which are fixed by the book. In a partnership firm, I can negate it at will. I can close it at will. Suddenly today morning, I can decide that I do not wish to be a partner of this firm and I can close it. If it is a partnership of more than one person, now the others would be equally be affected by virtue of my closure. So that distinction, was not taken into consideration when this was framed, because this is 1882. Partnership Act is 1932. Companies Act 1956. So therefore, all that fell into the zone of consideration in money. And finally, since a specific averment was made in SP money that the second accused, first accused is a partnership firm, second accused is the sole partner. So therefore, naturally, you're held liable. The same analogy cannot be affixed to a company. That is why 2023 distinguishes SP money. In this, from para 5 onwards, particularly may kindly request overleaf, that is the page 476, the fact in that particular case which was extracted. In quote unquote, accused 2 to 7 are fully aware of the business transactions of accused 1 company. They are jointly and severally liable. This is the language employed even in the instant case. Now, may kindly request from para 8 onwards. 6 and 7 are also necessary, but may humbly request from para 8. Now we come to the averments made in para 7. Firstly, it is stated that all the directors were liable for the transactions of accused 1 company. Secondly, it is stated that all the accused were fully aware of the issuance of the check, subject matter of the complaint, and they were also aware that the checks will be dishonored. Further, it is alleged that all the accused knew that there were no funds in the account of accused 1 company. Subsection 1 of 141 required the complainant to be aware that the present appellants at the time of commission of the offence were in charge of and were responsible to the company for the conduct of the business of the company. In the present case, all that the second respondent has alleged is that the appellants were liable for transactions and they were fully aware of the issuance and dishonor of the checks. Therefore, even if we decide to take a broad and liberal view of the pleadings in the complaint, we are unable to draw a conclusion that compliance with the requirements of subsection 1 of 141 was made by the second respondent. The most important averment which is required by subsection 1 of 141 is that the directors were in charge of and were responsible for the conduct of the company. The appellants are neither the signatories to the checks nor are whole-time directors. The decision in SP money will have no application as in the present case. The statutory notice was admittedly not served to the accused. Obviously, the High Court has not adverted to aforesaid 2 glaring deficiencies in the complaint. In fact, this case,
here notice was given.
Notice was given. I am not disputing. But the first part is where it is satisfied in instant case. So in this case, again, there are 2 batches. One batch are those who satisfy only section 2 clause 34. They are directors. The others who are probably defined under section 2 clause 54. They are also dealt with here. That particular paragraphs start from para 21. Facts let's not. May kindly request para 21 that is in respect of the others. Oh, may I kindly trouble this court with para 17.
17.
Yes, rightfully brought to my notice. The averments made in the complaints which are subject matter of these 3 appeals are identical. We are referring to the averments made herein. It is submitted that the complainant bearing number so and so. May kindly request the next paragraph. Accused 1 is a private limited company. That's the please to get it. Accused 1 is a private limited company concerned and registered under the Companies Act. 2 is chairman of A1. 3 is the managing director of A2, and accused 4 to 7 are the directors of A1. A2 to A7 are the managing the company and busy with day-to-day affairs of the company, and all are managing the company and are in charge of the company, and all are jointly and severally liable for the acts of accused 1 company. So this is the paragraph extracted from the complaint. Now, para 20. Para 18 Ashok Mal Bafna is referred. Para 19 SP money. Para 20.
Yes.
After having considered the submissions, we are of the view that there is non-compliance on the part of the second respondent with the requirements of subsection 1 of section 141. We may note here that we are dealing with appellants who have been alleged to be directors of A1 company. We are not dealing with the cases of a managing director or a whole-time director. The appellants have not signed the checks. In the fact of these three cases, the checks have been signed by the managing director, not by any of the appellants. Section 141 is an exception to the normal rule that there cannot be any vicarious liability when it comes to a penal provision. The vicarious liability is attracted when the ingredients of subclause 1 of 141 are satisfied. This section provides that every person who at the time the offence committed was in charge of and was responsible to the company for the conduct of the business as well as the company shall be deemed to be guilty of offence under 138. In the light of the subsection 1 of 141, we have perused the averments made in the complaints. The allegation in para 1 is that the appellants are managing the company and busy with day-to-day affairs of the company. It is further averred that they are also in charge of the company and are jointly and severally liable for the acts of the accused one company. The requirements of subsection, this is a repetition, so I kindly request 5 lines from there to merely because somebody is 5 lines from there.
Yes.
Merely because somebody is managing the affairs of the company per se, he does not become in charge of the conduct of the business of the company or the person responsible for the company for the conduct of the business of the company. For example, in a given case, a manager of a company may be managing the business only on the ground that he's managing, he cannot be roped in based on subsection 1. Para 23, day-to-day affairs was also read out. Was also dealt with. Second allegation, appellants are busy with day-to-day affairs. This is hardly relevant in the context of subsection 1. The allegation that they're in charge is neither here nor there, and by no stretch of imagination or on the basis of such averment, one cannot conclude with the allegation. So therefore, money, SP money was dealt by 2023 8 SCC 473. This is the Ashok Shevakramani.
Yes.
And others.
Further also it is there in that para 23 last only by saying that a person was in charge of a company
at the time when the offence is not sufficient to attract. Also, that rider is also there. Only by saying that a person was in charge at the time when the offence was is not sufficient to attract. Very clear. So,
yes. What is
just to
Yes, sir, I have answered.
you have that answer again?
Yes.
That is
Just now my friend has given,
well,
which
let's
was
finish minutes with all my contentions that my friend had.
that was considered by the latest.
because you were reading SP money.
Yes,
he
ma'am.
has given this
Yes,
as it is.
The 2025 judgment, just now I referred.
The Muskan Enterprises, which was read and reread minutes, para 20 particularly.
Muskan is with regard to cognizance.
No, second petition minutes.
Oh,
Second petition.
Maintainability.
Maintainability. Now, para 21 minutes it comes into play where and to guide us minutes as to which judgment would be relevant at the current point of time. Coordinate bench, the latest operating in that particular latest operating in the field of that proposition of law should be considered. May I just give a quick read of it? No, lots may not flip the papers. That the decisions in Surendra Singh Deswal and Jambu Bhandar have been rendered by benches of co-equal strength have not escaped our notice. However, notwithstanding the legal position that a cleavage of opinion is discernible owing to Jambu Bhandari seeking to explain the law by reading a limited discretion that an appellate court has been conferred with by subsection 1 of 148, which the decision in the Deswal did not read. The latter bench, while deciding the matter before it having considered the decision of the former bench, it is the decision of the latter bench which is now the law. This is to support my contention as to how
It is by the coordinate bench.
Ashok Chakravarti now holds the field because they're not. It's not only coordinate bench by virtue of para 21 where it holds the field. They distinguish SP money as well. Clearly, it is mentioned
By
in
the coordinate bench, and it's a later judgment according to.
Yes. The HDFC judgment, which my friend again referred to, which your lordships are also kind in. Para 5 holds the field for that judgment because there's a clear error, which is absent in the instant case. Both of us are fishing in such waters, where there is no.
And these judgments are not referred to larger bench.
No. Because fundamentally, the law that parameters of 141, subclause 1 and
Followed
subclause
by
2, SMS Pharma and Ashok Mal Bafna, they continue to hold the field. It's like
by
a,
larger bench, however.
yes, it's a bench of 3. Yes, like a poll, my lords. Every other case revolves around it. These 2 judgments hold the field. It's
And Ashok Mal Bafles, basically, what are the facts of that case?
it's direct, same thing. It's a direct. He was
Under
he was a
141,
director.
unless
Yes, para
conduct
9,
of.
para 9 up to 12, and incidentally they refer to the cognizance part also. For that cognizance part, I will provide. Yes. Yes. On cognizance, my lord, this is the latest, 30th January 2025. In fact, this copy would be available in the bundle minutes, but allow me to
Yes,
just
yes,
pass
it
on
is
this.
there, Ashok.
No, not Bafna. This is 30th January 2025 minutes. JM Laboratories,
With regard to,
cognizance.
with, he was referring to STC and.
Now, all that minutes would fail into insignificance by virtue of this latest in the
According to him, as it is STC, reasonable order
minutes.
is not required or application of mind.
For that minutes, my answer is plainly simple. The circular is of 2021. It's only circular guiding it. Circular was issued based upon one judgment of All India Bankers Association. In the circular minutes, if you may.
Yes, they have referred to that. So, see.
Page 82 and
Of
particularly
his
84
counter, I
if
think.
I'm not in his counter. Yes,
Yes.
Page 82 minutes under practice directions, clause 1. All the magistrate courts trying the cases under 138 shall invariably follow the directions of the Honorable Supreme Court Indian Banks Association, which is 2014. Now, milords, 2025, this judgment holds the field. So, circular milords will not, with all due respect.
No, what does it decide?
Cognizance orders, you have to necessarily give reasons.
If it is STC or even.
Or irrespective of STC or irrespective of the summary stage.
Okay. Please.
And to follow that, milords,
Which paragraph is that relevant?
it's a short judgment, milords, all the paragraphs, quote of paragraph on this passage. In fact, they clearly write, milords, that while several submissions have been raised, we do not find it necessary to consider the submissions made by the appellants on various grounds, in as much as the present appeal is liable to be allowed on the short ground that the learned magistrate has issued process without assigning any results. This is whereas Bafna and SMS Pharma, milords, were followed. Whereas
What are the facts there? Facts. Second para is.
Yes. On 29th May 2019, Drugs Inspector filed a complaint under CC 1051 in the court of and under Section 32 of the Drugs and Cosmetics Act 1940. Complainant picked up a sample of drug milords. Pursuant to the trial court by order, summoned the appellants herein and directed them to appear before it on 10th August 2023. Appellants herein filed a petition praying that the High Court quash the criminal proceedings against them. Particularly, the grounds raised were bar of limitation under 468 clause 2 of CRPC.
I think it's not relevant there. CC is there, not STC or something.
Not in this.
Even then milords, this is 2022. 2 judgments were rendered by the Supreme Court on the cognizance part under 138. May I just pass on? The first judgment is 2022 16 SEC 762. This is under NI Act, milords, para 39. 2022 16 SEC. For 39, milords, is on page 786.
Yes, yes. I'm on that page.
Yes. Magistrate is duty bound to apply his mind. This is independent of summary stage and STC cognizance. In fact, milords, this judgment also helps me elaborate my argument to the extent that 202 stage, this is necessary. The reason being, the respondents added as accused, the petition before your lordships now is outside the territorial jurisdiction of the court. In that trigger, when that is the case, under 202 inquiry is mandatory. That's where Milord's para 39 gives me that guidance. This, and expeditious trial judgment was also referred to, saying that even if that is the case, inquiry and notice application of mind is necessary. Milord's paragraphs 39 to 45 minutes. Ashok Mal Bafna is also referred to. (39 minutes), section 202 and 204 were dealt with. Para 44 minutes is where reference to the constitutional bench is found. Para 44.